All right, I think we have everybody. Good afternoon. I'm Diana Moss, president of the American Antitrust Institute. We are delighted to see you virtually today for a discussion on what constitutes illegal price fixing, a discussion among experts on tightening judicial standards. Thanks to our co-host and supporter, Rust Consulting, Kinsella Media, for helping us make this event possible. And with us today are 5 leading experts and thought leaders in antitrust enforcement. They are members of the AAI Advisory Board or our staff, and we are very proud to feature them. Let me briefly provide some context to center today's discussion and create a bridge from competition policy to the antitrust enforcement domain. As the leading proponent of strong enforcement, AAI analyzes and advocates. We have been outspoken on the decline in federal antitrust enforcement over the last 40 years and its implications for consumers, workers, and markets. We recently issued our landmark report, The State of Antitrust Enforcement and Competition Policy, and in it, we draw attention to continued weakness in federal enforcement across all areas of the law, mergers, agreements, and monopolies. We highlight how state and private enforcers can take up some of the slack from federal inaction. AAI also emphasized in the report that Section 1 enforcement is currently one of the most important tools we have to address illegal, harmful conduct in markets dominated by oligopolies. And the reason is this: concentration is on the rise, and now with only a few firms remaining in many critical markets in the US economy, merger control is more limited in its ability to promote competition. So this shines the light on the importance of Section 1 enforcement. But that area of the law is itself under attack as standards for showing collusion tighten. This problem is what today's discussion will take up, and is a vital conversation grounded in the idea that well-functioning markets are an important part of our democratic system, that markets need referees to ensure that they don't come to be controlled by monopolies or oligopolies, and that vigorous enforcement ensures that the players follow the rules of the competition game. So today we are joined by 5 speakers, 5 panelists. Our panel moderator is Ellen Meriwether, partner at Cafferty, Clobes, Meriwether, and Sprengel. We've got Andrew Gavil, professor of law at Howard University School of Law. We have Daniel Hedlund, member of Gustafson, Gluek, and we have Hollis, Salzman, partner at Robbins Kaplan. Also joining is Laura Alexander, AAI's vice president for policy, who joined us in January. Welcome all, thank you for attending, and I will turn it over to Laura for a few more comments.
Thanks, Diana. And thank you to Rust Consulting for hosting this event, and to Ellen and the rest of our terrific panelists. As Diana articulated, AAI's State of Enforcement report is really a comprehensive look at every aspect of antitrust enforcement in recent years. One of those aspects is the focus of today's panel, the judicial standards under Section 1 of the Sherman Act for collusion. Section 1 enforcement is the bread and butter of antitrust enforcement. As such, it's critical to antitrust enforcement and thus a core concern of AAI's. Although collusive conduct and price fixing in particular is often thought of as the most straightforward piece of antitrust enforcement, the collusion standards under Section 1 have become complex, confusing, and have led to several troubling issues that led us to convene today's panel. One of the many troubling enforcement issues discussed in our State of Enforcement report is that the standards for Section 1 collusion at the motion to dismiss and summary judgment stages have remained largely nominally the same for nearly 40 years. But when one looks at the cases, it's clear that the bar for the amount and type of evidence and allegations that courts are now demanding to satisfy those standards has been steadily rising. As a result, Section 1 collusion cases, those cases that form the core of antitrust enforcement, have become harder and harder for private plaintiffs and public enforcers to win on the merits, or even to survive long enough to get to discovery. These cases have not only become harder to win, but what will or will not satisfy the courts at each stage of the inquiry has also become harder to predict. We see complaints dismissed today, even though they contain more detailed, substantive, and suggestive allegations than complaints that passed muster 10, 20, or 30 years ago. This directly harms the ability to effectively enforce the antitrust laws. And we also see an alarming lack of consistency in the application of these standards among various courts and judges. this presents a serious issue for the rule of law. Most importantly, as documented in our State of Enforcement report, and as Diana mentioned, we see a consistent decline in the successful prosecution of Section 1 collusion claims without any indication that there's actually less collusion taking place, and in the face of well-documented and dramatic increases in market concentration and market power. This is a problem for all who value free and competitive markets and the protection of consumer welfare. Fortunately, the members of today's panel are some of the foremost thinkers and advocates on these issues who have been working on these issues for many years. While I don't know that we'll arrive at any ultimate solutions today, I'm confident that discussions like this are the key to pointing the way forward. So thank you to all of those of you in attendance today for joining us as we work towards resolving these tough issues. And with that, I will turn the microphone over to one of those leading the way on this issue, who will also be leading our discussion today. Ellen?
Thank you, Laura. At the risk of repeating some of the really important concepts that we've already discussed today, I wanted to point out that the AAI report is in our materials. And if you review it, you'll see that it does detail a troubling lack of antitrust enforcement from over the decades. Our economy today is grappling with the results of these trends. There is growing concerns over giant companies that appear to have too much control over our economic and private lives. There are reports of killer acquisitions of innovative technologies that further entrench monopoly power. There is a concern about highly concentrated markets that exhibit anti-competitive tendencies. And most recently, we have suffered supply chain disruptions in crucial markets caused by economic shocks such as the COVID-19 crisis. There can be no clearer example of the interplay between lax enforcement, rising concentration, inefficiencies, and disruptions than what has recently happened in the beef, pork, and chicken processing markets. For years, progressive antitrust voices have expressed concern over excessive concentration in these markets. And today, more than 80% of the processing of meat in these markets is controlled by a few large firms. Disruptions at some of those firms caused by COVID-19 plant-related closures have forced the Trump administration to invoke the Defense Production Act just to secure the food supply chain during the crisis. Meanwhile, prior to the scrutiny on these industries engendered by the recent crisis, each was the target of a private enforcement case challenging anti-competitive conduct. Indeed, private enforcement actions in the poultry and beef market preceded the interest that governments had in these industries, an interest that led the DOJ to indict corporate executives of a major poultry processing firm, and has led to reports of DOJ and AG investigations of cattle procurement practices in large beef processing firms. So it is clear that in this environment, private enforcement is all the more important. But yet, as Laura discussed, tightening judicial standards have made bringing and proving collusion cases more difficult than ever. Twombly and Iqbal have made surviving motions to dismiss a challenge laced with uncertainty. Misapplication of Matsushita has prevented jury resolution of important cases, and heightened class certification requirements, including the requirement for complicated and expensive analysis at the class certification stage, coupled with growing suspicion, judicial suspicion and mistrust of regressions and other economic analyses, have made Section 1 cases more difficult to win, and therefore anti-competitive conduct more difficult to deter. This panel today will discuss one aspect of the tightening of judicial standards in this area, specifically standards required to plead and prove collusion in Section 1 cases. Despite the many successful Section 1 cases, it is beyond dispute that over the past 20 years, there has been a changing judicial view of facts that are indicative of independent decision-making in concentrated markets and those that are indicative of collusion. Andy Gavil will lead the discussion on the changing judicial perspectives, on the quantum of evidence or allegations needed to overcome motion to dismiss and summary judgment. We'll then turn the floor to Hollis Salzman, who will lead a discussion into the meaning of what direct evidence is as opposed to circumstantial evidence, generally and specifically as applied in cases. And Dan Hedlund will then dive deeper into circumstantial evidence, what constitutes parallel conduct, what plus factors are considered both favorably and unfavorably by courts. With that being said, I will turn the podium over to Andy.
Thank you, Ellen, and thank you to AAI and Russ Consulting, and especially to you, Ellen, for getting us so organized and doing so much work to put our program together. I thought I'd start off just by talking about two groups of cases that frame our discussion. And these two groups of cases also have shaped what we're seeing as a continuing and ongoing debate about what would appear to be a very basic question under Section 1. What is an agreement? What do we mean by conspiracy? Why is this so consequential? Why do we battle over this issue of agreement? Because many of these cases are involving per se unlawful violations. So proof of agreement is equal to proof of the violation. That doesn't mean that there aren't other issues like damages to be shown, but it has created sort of a perfect storm of litigation incentives, all focused on agreement. And that has been true for decades. It's also true that we have these procedural complications, and we'll be talking about that a lot. How are the standards applied to motions to dismiss versus summary judgment? What do we mean by plus factors and circumstantial evidence? What do we mean by direct evidence? Surprisingly, as has already been mentioned, the courts are really not very consistent at all, and that's a function in part of the standards that I'm going to talk about in a moment. So these two groups of cases. We go back to our formative cases in the 1940s of Interstate Circuit and Theater Enterprises. And that's really where the story begins of the court recognizing a series of propositions that Section 1 does require agreement. It later described that in Copperweld as the concerted action requirement of Section 1. And the court has repeated since then many times that parallel conduct is not enough. There must be something more than parallel conduct. And Interstate Circuit is really the case that sets in motion this notion of having parallelism plus, we start the analysis with some observation of parallel conduct. Typically, we're talking about price fixing, but there must be some additional evidence that we have called plus factors, and we'll be talking about that as we go on. But explicit agreement Interstate Circuit is not required. It can, and it was in the case of Interstate Circuit, be enough to show agreement through circumstantial evidence. There's a lot of confusion about the language that we use and how we use tacit as opposed to express. But the core concept here is that, yes, you can have express agreement, and there are many Section 1 cases that involve things that were uncontested. Think of cases like Superior Court Trial Lawyers Association, National Society of Professional Engineers, California Dental. The list goes on where there really was no debate about agreement among the rivals, conspirators. So we're talking about cases where, at least on the face of it, the defendants are denying that they colluded, and it becomes necessary to prove it. There is not explicit evidence. And here's where we get into a linguistic problem of how we use the term tacit. Often this interdependence is referred to as tacit collusion, but the point that we're really trying to get at is something more akin to tacit agreement, or agreement that is implied from circumstantial evidence. One of the articles we circulate for you is an article by Bill Page called Tacit Agreement, and he does a terrific job, I think, of trying to explain how we've gotten tied up a bit in the language. So what came out of this first group of cases are a set of principles. Parallelism not enough, you need plus factors in order to show agreement, but it doesn't have to be explicit. If we jump forward in time, that law was developing, but developing relatively slowly. And we come forward to 1986 in the Matsushita decision, Matsushita has many dimensions to it. I'd recommend to you a symposium that we did in the Antitrust Law Journal just a couple of years ago, looking back at the many facets of Matsushita. We sometimes think of it as a conspiracy case, sometimes as a predatory pricing case, but it was one of 3 decisions that term by the court dealing with summary judgment. And it was very much intended to revive the use of summary judgment, rejecting the view that some of you will recall from the Pollard case from the 1950s, that summary judgment is somehow ill-fitting for antitrust cases. Matsushita does that by embracing a phrase that it actually took from Monsanto. What we want is evidence that tends to exclude the possibility of unilateral action. It raises the seemingly high bar. It uses the concept of plausibility in the context of summary judgment, but also in the context of a conspiracy to engage in predatory pricing, which the court described as highly implausible as a matter of economics. That framing has sort of taken on a life of its own. It has been used in many different contexts. Some of the courts of appeals have been more careful, noting that in Matsushita, the tends to exclude the possibility was a way of calibrating for implausible conspiracies. But other courts have just used it as the baseline standard for all kinds of conspiracies, even those that involve more typical cartels that are easily distinguishable from Matsushita. Again, we sort of move forward another several decades, and Twombly in 2007 takes that basic framework from Matsushita and it accelerates it to the pleading stage. And it says now, in order to plead an antitrust violation of Section 1, you also have to meet the plausibility standard. What that means and how courts have applied that is going to take up much of our discussion today, because what we find when we look around the various circuits and the district courts is a lot of differential treatment, a lot of differential application of Twombly, of Matsushita, of plausibility, which injected a dose of discretion into the district courts to evaluate both pleadings and production at the summary judgment stage. We're going to see loosely used summary judgment cases in the context of motions to dismiss. And although some circuits have differentiated appropriately as a procedural matter between the two, many have not. So where are we at this point? We come back to some of the core requirements. The language of Section 1 clearly requires some kind of agreement. Oligopolistic interdependence is something that is widely recognized as a phenomena that does not violate Section 1, and some of the arguments raised as to why it's hard to remedy it have been very influential over the years. That was a debate originally developed by Posner and Turner through articles in the 1960s, and it's revived again in some slapping around of Judge Posner having changed his view of Professor Louis Kaplan in one of his text messaging decisions. So we are left with a surprising amount of lack of continuity and consistency in the cases. That's the cause for our program today. And we're going to talk about these various issues. What do we mean by a plus factor? How do we differentiate direct from circumstantial evidence? And how are courts using this Twombly-Matsushita framework at the motion to dismiss and the summary judgment stage?
Andy, thank you. I want to throw a question out there. What, in your view, distinguishes how courts evaluate plausibility at the motion to dismiss phase and how that relates to, tends to exclude the possibility at the summary judgment phase?
Well, there's what I think and there's what courts are doing. And I think that's part of the problem, is that the courts are very inconsistent in how they're answering that question. I think the two text messaging decisions written by Judge Posner offer a good example of how to make that distinction. He points out in the first text messaging decision that plausibility lies along a continuum of probability, and probability can run from 0 to 100. And he interprets Twombly as saying that whereas possibility, which would be a low probability, used to be enough, plausibility is something a little bit more than that, but plausibility is not necessarily more likely than not. That's something that we associate with the burden of proof, and that's something for a later stage of the proceedings. I think that that's actually a very helpful and procedurally appropriate framing, but some have criticized that too and said that no, the district court, in its discretion, in judging plausibility, has to make some kind of threshold decision as to whether or not, and it comes out as whether the inferences are equally plausible. If that's true for some courts, that's not enough. Under Posner's framework, that would be enough. If they're equally plausible, well, that's not a mere possibility. That's the kind of case that should go on to discovery.
Yeah, so I would agree with the fact that courts disagree on that, and I wanted to point out language from a recent decision in the Saline case. There's been 2 of them. This is the first one. And the court says there, but these factors that it's talking about, the various evidence, the plus factors, standing alone or considered collectively, are no more probative of an agreement than of independent self-interested conduct. And as such, Twombly instructs they're inadequate to state a claim. So that court is at least one which construes Twombly as requiring that there be some sort of weighing of inferences at the motion to dismiss stage, and that you need 51%, or at least that's how I read it. If it's just as consistent either way, that it's not enough. But I agree that there's been a little bit of disagreement on that.
Ellen, I would add quickly that just the use of the word probative, I think, is actually very revealing, because that's a word that we typically associate with evidence, not with allegations.
True. We have a polling question to put up. Polling question number 1 that arises from your comments about how courts may look at this certain ways. And can we get that polling question number 1 put up? Yes. Agree or disagree? Everybody gets to vote on this. Agree or disagree? Courts apply the plausibility standard of Twombly consistently, so cases based on similar allegations are decided the same way most of the time. Go ahead, make your votes. And while you're voting, I want to call your attention to another bit of something in the materials. Our firm put together, Cafferty, Clobes, Meriwether, and Sprengel, that has put together what we call a Section 1 update. And it was sort of a brainchild coming out of recent briefing, but there are so many cases that talk about pleading the facts needed to either allege conspiracy or prove conspiracy in the motion to dismiss and summary judgment phase, that we made a chart of how cases are going in either direction. And it might be helpful in your briefing if you've got cases that you want to use in your briefing that, for instance, discuss economic evidence or direct evidence or plus factors. They're sort of listed there. So, any other comments from the panel while we're waiting for this? Do we have the results yet? All right, that's pretty much what I thought would happen. 67% plus 28% is a pretty high percentage of disagreements.
Ellen, I don't know if you saw a question about asking where the materials can be found.
And that question, I will have to throw over to someone to answer from AAI, who will probably let me know, and I will disclose it. How's that?
Right now they're at an undisclosed location.
Yes. I thought they were posted on the where you sign up. They were posted, but somebody will let me know, and I will reveal that information once I have it.
Yes, if you go to the AAI website where there's a link to this event, you should be able to find the materials there. But I will also see if we can email a link directly to the participants, so you have it for easy reference.
That's terrific. Okay, so let's turn for a minute, for the little bit that we have left. Let's say we get past the motion to dismiss phase and we're at the motion, and discovery's been taken, and now it's summary judgment. What do you see that the courts are expecting by way of evidence or an evidentiary presentation at the summary judgment stage?
So I think that that's, in many ways, that's the million-dollar question these days. Is it has always been clear, until recently, I think, that you don't need direct evidence. Now we're going to get into a discussion of how we define direct evidence. But I think it is becoming increasingly difficult to get past the summary judgment stage if you don't have direct evidence. And that concerns me. And I think you see that in some of the decisions. The attitude of some courts appears to be, well, you've been given the opportunity to do discovery now. You've gone through the expense. And if you haven't come up with that direct evidence, if you don't really have the kind of, smoking gun evidence of agreement, no reasonable jury can find for you. That is certainly, if that's happening, that's very inconsistent with the long history of circumstantial evidence being enough. It was certainly not true in interstate circuit. The court, in fact, made a point of saying that all of the alleged co-conspirators refused to testify. And so the direct evidence was not there. It was entirely circumstantial. And there have been many cases since then that have rested on circumstantial. But one of the issues I hope our panelists will continue discussing, and Hollis and Dan and you, Ellen, have all been very involved in these litigations, is do you feel like when you get to the summary judgment stage that the courts are being very, very demanding, having allowed the opportunity for discovery? And one thing that has been happening, I know we're going to talk about this too, is that courts seem to perceive that direct evidence is more probative, and they will try to recharacterize things that a plaintiff views as direct as circumstantial in order to sort of denigrate it and more easily set it aside. So that's where I think the answer to your question brings us to this larger issue today of what kind of evidence and how evidence is characterized by courts when they're applying the Matsushita standard at the summary judgment stage.
I tend to agree with you, and I also tend to agree strongly that it depends on the definition of direct evidence. You may not need a guilty plea, but you need something interesting. I'm going to put up polling question number 2 now, if we could do that. This relates directly to that point. And some people may have a different opinion on this based on their actual experiences, but the question is agree or disagree. Absent direct evidence of agreement, it has become increasingly difficult for a plaintiff to survive past the summary judgment stage. So while people are voting on that, I would point out a couple of things. I looked at some of the summary judgment decisions, three that went in against plaintiffs, Valspar, the container board case, Clean, K-L-E-E-N, and the text messaging summary judgment opinion by Judge Posner. And in each of those, there was at least a suggestion of some kind of corporate insider comment that those courts thought was just not indicative enough of agreement. That could be contrasted to the high fructose corn syrup decision that Judge Posner issued probably many years ago now. It's probably a pretty long time ago. But the comment in there that he thought was interesting was this one, quote, "We have an understanding within the industry not to undercut each other's prices." So depending upon who said that, that could clearly be a direct evidence, and maybe it proves Andy's point. And also in that case, there was some email that said something like about new entrants, will they play by the rules, paren discipline? And of course, that's a key word for we have an agreement, how are we going to make them abide by it? So a lot of people agree with this idea that if you're allowed, God bless you, to go through discovery, you better find something that's close to or tantamount to direct evidence, or you may not be able to get the case to the jury. Anybody else, any comments on that? We alluded a little earlier to direct and circumstantial evidence, and Hollis is going to take that up. What is direct evidence, and how is it used, and why is it important, and then what's circumstantial evidence? Hollis, you're muted.
Thank you, Ellen. Essentially, direct evidence is what you would think. It's a smoking gun. Courts have articulated exactly what direct evidence is in slightly different ways. For example, in the Frost versus Electronics case at a Ninth Circuit, which we'll talk about in more detail later, the court stated that direct evidence must be explicit and require no inferences to establish the existence of the conspiracy. In the Golden Bridge Tech versus Motorola case, the court said it must show an explicit understanding between the alleged co-conspirators to collude. And one court, the Highland versus Home Services, that was the Sixth Circuit, quoting from the high fructose corn syrup, actually said it's tantamount to acknowledgement of guilt. So that's pretty strong what some courts are looking for direct evidence. And examples of direct evidence that we would put into our complaints when we're, hopefully before we're filing them, unfortunately, unless there is an amnesty applicant who's giving us evidence, we don't often have a lot of direct evidence. But in some cases with the amnesty applicant, we've been lucky to have documents that said in the subject line, delete after reading, or X price will be the floor. Make sure competitor A is on board. All future discussions should take place over the phone. Of course, that's the dream document and information that we all want to have for our cases. Other examples of direct evidence would be telephone recordings and chat room discussions, evidencing an agreement on price that we saw in the GSC bonds case, a guilty plea. Although I'll say in the air cargo litigation, which was some time ago, that initially the complaint was dismissed despite the fact there were 7 guilty pleas. And by the time the complaint worked itself through the system, when we filed again, we had 50 guilty pleas and were able to get past the motion to dismiss. So that's probably pretty extraordinary. It's not always easy to categorize what's direct and what's indirect. For example, a guilty plea, which I just said was direct evidence, may not be enough if the guilty plea is not as broad as the allegations in your complaint. And often, guilty pleas, as we know, are negotiated by experienced defense counsel who try to get the most narrow conspiratorial period, and it's not always a fair time period or scope of a conspiracy. And so quite often the private complaints are much broader. And so that won't always help you. Also, if you look, for example, in the packaged seafood case, the court held that plaintiff's allegations regarding agreements about the price of tuna were insufficient to support the full allegations of the complaint, which was the packaged seafood market. And I think that's, an example also where your direct evidence is not broad enough to protect your complaint. I think this might be a good time for polling question 3.
Sounds like a plan.
Okay.
Polling question 3, is evidence of a single discussion in which competitors agreed to set a price direct evidence of conspiracy? This might be a time to sort of reiterate what Andy said about direct evidence. It's considered to be such an important event that there seems to be some tendency of judges to have direct evidence be beauty in the eye of the beholder. And if they are suspicious that the evidence isn't quite enough, they may play with its characterization, and so as to maybe dismiss with leave to replete or whatever. But it is, it seems like a single discussion should be enough, but maybe it isn't. So do we have an answer? All right, that seems to be consistent, I think, Hollis, with what you were proposing, or at least what a lot of people are proposing, that it should be enough. So that's a good yes, but there are times when courts do not accept it as sufficient direct evidence, maybe because of a lack of contiguousness vis-a-vis who's discussing the price and what the allegation of the complaint are. What about that Cedar Shakes case? Was there some issue about direct evidence in that case?
Yeah, so in the Cedar Shakes case, there the plaintiffs who were purchasers alleged that defendant manufacturers raised prices, and they threatened them with expulsion from a trade group in order to try to enforce this price increase. There was this direct evidence of the plaintiffs being pressured in the trade groups, and there was some other very minor direct evidentiary support, and then there was a lot of what I think is a lot of circumstantial evidence. There was parallel conduct, group boycotts, geographic proximity of the defendants, opportunities to meet, those types of allegations. However, the court granted the motion to dismiss the antitrust claims because the court did not find out that the direct evidence proved the existence of the conspiracy, and that was because there was no evidence that anyone was actually terminated from the trade group if they didn't raise the price. So the court, I think the question is, was it not artfully pled to include things that might have enticed the court to sustain the complaint, or was there truly not enough evidence in that case?
It almost sounds like that debate between the existence of agreement and its efficacy, and the agreement's there, it should be enough, even if it doesn't always work. But anyway, that just goes to prove up the fact that direct evidence, even if you think you have it, you may not. And so what does it matter if it's not accepted as direct? Why do we care whether something's direct evidence or not?
Well, direct evidence is going to be a stronger persuasive allegation to the court. But if we look at Judge Posner's decision in the high fructose corn syrup, and of course that was a summary judgment decision, but he is obviously a well-regarded judge, and his basic premise was you look to everything. It's not just direct, it's not just circumstantial, it's everything. Does it get you over the goalpost? I think the quote from the case was, the distinction between the direct and circumstantial evidence, he said it's confusing and largely, if not entirely, superfluous. And he said it does, basically he said it doesn't matter, look at the whole picture. And right. I think that's really what we're all trying to do when we're, pleading our allegations, is we put in absolutely as much as we can because we have to, and whether it's direct or circumstantial, we're doing the best we can without discovery yet in the case.
Yeah, and we should be ready to pivot if we make an argument that something is direct evidence, that we should be able to pivot and say, even if it's not direct evidence, that considered along with all of the other evidence, it's clearly more than enough to support the plausibility of the claim of conspiracy at this point.
Yeah.
There's a recent case out of the Ninth Circuit, Frost v. LG Electronics, in which at least it was putatively direct evidence, and yet it was dismissed, and the Ninth Circuit affirmed dismissal. Let's talk about that case for a minute.
Sure. And this is a case that AAI filed an amicus brief, and Laura's going to talk about that in a little bit. But basically, the evidence in the direct evidence in the case were plaintiff's allegations that the named plaintiff was actually told by third parties and high-ranking executives on several occasions that the defendants had an agreement not to hire each other's employees. That's pretty strong to me. A high-ranking human resource employee at an India, the country of India branch, made a public statement that the defendants had, in fact, this understanding not to hire each other's employees. Plaintiffs were unable to get interviews at another defendants within a year of leaving their employment. And there was sort of this other allegation that the agreement took place among Korean defendants, but the actual employees were located in the United States, and one wonders how much that impacted the judge's decision. And there was also a variety of circumstantial evidence that was alleged in the case, but the court decision didn't really hinge on whether the evidence or the allegations were direct or circumstantial. Court did not think that the plaintiffs adequately pled specific time, place, or person involved in the case. And that was the biggest reason. So I think the court eventually thought that it lacked direct evidence, it lacked, it was insufficient circumstantial evidence, and there was a failure to plead a who, what, where, and when. And then I personally think that it sets a very high bar for plaintiff allegations in a complaint, and I'm hopeful that this is an isolated case in the Ninth Circuit and not one that will catch on in other jurisdictions, but we'll see. Laura, would you tell us a little bit about the issues that concerned AAI and the amicus brief that you've filed on those issues?
Sure. So yes, as Hollis said, this was a very troubling case out of the Ninth Circuit. Hollis described the evidence, which whether you characterize it as circumstantial or direct evidence, was certainly, in my mind, and I think in the mind of many of the folks who viewed it, strong independent evidence that there was a no poaching agreement. And it was the kind of evidence you, as a practitioner, kind of hope to have and often don't have. So we felt it was important to file in this case because the Ninth Circuit law has really gone in a direction that is troubling, and this case was a prime example of it. It's not simply the characterization of direct and circumstantial evidence, although I think that the court did get it wrong, and we argued that the court got it wrong, and this was direct evidence. But in the Ninth Circuit, the way their law has developed in Section 1 cases is to hold that there are only two paths to pleading a Section 1 case. The first path is to use parallel conduct plus factors, a la Matsushita and progeny. And the only other path available, according to the Ninth Circuit, is to plead direct evidence. And when you plead direct evidence, according to the Ninth Circuit, it's not sufficient to simply have direct evidence, say, an email or a discussion from one of the conspiracy participants referencing the conspiracy. You must also plead who did what to whom, the who, what, when, where, why parameters of the conspiracy. And this is a motion to dismiss case. So this is all before discovery. They are demanding that any case, even if you have direct evidence, has that level of detail. Now, they base that on a footnote in Twombly, but that footnote in Twombly was dicta, and we felt that was an important point to make. Twombly was a parallel conduct case where they were using parallel conduct with plus factors to establish the case, and so it didn't concern the alternative scenario where you aren't using the parallel conduct path. And so the remark in the footnote had to do with that alternative path that wasn't even at issue. Another thing that we felt it was critical to argue in Frost was that there is another path. Even when you don't have direct evidence, you're not limited to parallel conduct and plus factors. And this is something that Andy touched on in his comments. Parallel conduct with plus factors was important in Matsushita because it articulated a way to move forward even when you don't have the kind of independent evidence that was present in Frost and in other cases, where you have conduct that's not based on economic conditions or opportunities to collude or motive evidence. Instead, you have evidence that, whether direct or circumstantial, is expressly referencing the conspiracy and is from people who were involved in the conspiracy. And so in those circumstances, you aren't limited to parallel conduct with plus factors, and you aren't limited to direct evidence. Instead, you can use a combination of direct and circumstantial evidence to plead a conspiracy. Unfortunately, the district court in Frost didn't see it that way, notwithstanding the evidence that Hollis described. And the Ninth Circuit panel, which was Judge Nelson, Judge Fletcher, and Judge Malloy, who's a district court judge sitting by designation, was troubled by the law. And so we felt that was another important reason. We had judges on the panel who were voicing their discontent here. So Judge Nelson wrote the opinion affirming the district court. Judge Malloy concurred, but wrote separately to say that he believed the law was incorrect in the Ninth Circuit, but he felt bound to follow it. And Judge Fletcher wrote a dissent saying that if the law was as the majority said it was on the panel, that it conflicted with Twombly. He didn't elaborate on how, but I think the most straightforward way it conflicts with Twombly is that by demanding the who, what, when, where, why, it imposes a heightened pleading standard, which the court in Twombly expressly disclaimed that it was doing. Another way that it potentially conflicts with Twombly and with Iqbal is because the court essentially held that if evidence was not direct evidence and you weren't relying on parallel conduct with plus factors, they could disregard all of the circumstantial evidence. But Twombly and Iqbal were very clear that while you can discard and should discard conclusory allegations, that does not mean that you can discard allegations simply because they're based on circumstantial evidence. So we filed an amicus brief, and the case went up for consideration for en banc. Judge Fletcher voted to take the case en banc. Judge Nelson recommended, Judge Malloy recommended. As a district court judge, he doesn't get to vote. And unfortunately, none of the other members of the court wanted to take the case en banc. So that remains the law in the Ninth Circuit post-Frost.
So I just wanted to make a comment about that. I think there's many things wrong with that opinion. In a number of circuit courts, they make it clear, just like Judge Posner did in the summary judgment opinion, that it's the totality of the evidence. It doesn't have to be in a bucket of particular type. It's every evidence. You get to look at it all, weigh it all, and decide whether there's sufficient evidence to go to the jury or go past the motion to dismiss. I've been struck by the fact that the two categories are direct evidence and circumstantial evidence. And circumstantial evidence can be parallel conduct and plus factors, but can be anything else as well, which we'll get into. But collusive agreements can take the form of agreements that don't require everybody to do the same thing. There could be bid rigging or bid rotation agreements. There could be agreements to time certain things in a way that's not at the same time. So it just seems like a very short-sighted and odd result that if you don't have parallel conduct in a conspiracy that isn't about parallel conduct, like a no-poach agreement that's not about parallel conduct, you could lose. So one of the things that's important about getting a court to accept your evidence as direct evidence is that then you don't have to rely on permissible inferences. Different circuit courts have different rules about what kind of inferences are allowed to be weighed. And I think, Hollis, you had looked at this issue, which courts can you weigh inferences and which courts can't you? And where's the state of the law on that?
Right, so this came out of a published survey of the circuits on this issue. And the First, Second, and Sixth Circuits have mandated that district courts are not to weigh inferences on a motion to dismiss. So they only look at the plaintiff allegations and evaluate whether they create a plausible inference of the conspiracy. They don't look at the probability. And the Third, Fourth, Sixth, Ninth, and 11th Circuit permit the weighing of inferences. So that's really how the two are split.
I wanted to throw this question out to somebody who wants to get it, to pick it up. How do you view the weighing of inferences as consistent or inconsistent with Twombly? Well, I'll take it up if nobody else wants to. I don't think Twombly allowed for the weighing of inferences. I think that if the inference is reasonable, and they'll say things like in light of competing inferences, but if the inference is reasonable, then it's not up to the court, especially in a motion to dismiss, to weigh them. Any other comments on that? Okay.
I agree.
I think we're ready for another polling question here. Polling question number 4.
Great.
And this kind of encapsulates some of the things that we've been talking about. How important to the success of a Section 1 case is the assigned judge? 1, absolutely critical. We will dismiss a case if we draw what we believe to be an unfavorable judge. 2, important, but not as important as being in the right circuit. 3, not that important. We believe that good facts and good law will prevail in any court. Maybe that's a harder question. Certainly all of us are very in tuned to which judge we draw when we file our case, and hopeful that we draw one that we think views things like plausibility more favorable than others.
Alan, I would just, I would add one thing, is that whether it was intended or not, the use of the term plausibility injected a kind of discretion that can be very judge specific. Well, let's see what our results are out.
There we go. So most of you out there will hold firm if you've filed in the right place where you think the circuit court has shown, has the right opinions, and will be less worried about the specific judge.
So the response is really interesting, and I'll finish what I was going to say with the help of the response, that to some degree what the circuit courts are doing are informing the district courts of how to exercise the plausibility discretion. They're defining to some degree what they will believe is sufficiently plausible. That probably influences the district courts over time. But the larger point here is that there's no doubt that Twombly injected a degree of discretion into the motion to dismiss phase that's particularly evident in antitrust cases. You see it also in cases involving market definitions, with judges saying the market definition is implausible and therefore I dismiss. So you line up all of the hurdles to get through any kind of Section 1 case, whether it's a per se price fixing case or not. And this injection of plausibility has not been limited to conspiracy. It applies to various issues in the pleadings, and judges are using it as a filtering mechanism. Maybe that's what Twombly intended, but it certainly is a shifting of discretion to the district courts as guided by the courts of appeals.
Yeah, I'm going to have to agree with you there. I have seen a very annoying injection of Twombly in things like antitrust standing or injury and that sort of thing. There was one other point. Hollis, there's a question about the source of the survey on which the circuits allow the weighing of inferences at the motion to dismiss stage.
Yes, I can pull that and have it. We can have it posted.
Okay, great. And then there's one other thing, one other source that I would also refer to. I know that in the Antitrust magazine, which is a publication by the Antitrust section, and I'm an editor on it, so I read all the articles. There was an article on this by one of our editors, which was a good one, that went through the surveys and discussed the cases that allowed weighing of inferences, I think at both motion to dismiss and at summary judgment, but it could have been just motion to dismiss, but whether the circuit interpreted Twombly as allowing the weighing of competing inferences and discussed which cases. It's in the last year, and I'll try to find that as well. Do we want to wrap this section up, Hollis? Do you have any other things for?
I think we could go into Dan's section.
Okay. Well, we've talked a lot about direct evidence, but as we know, as litigants, we don't often have it or have access to it. So we often plead our cases, at least at the motion to dismiss phase when we first file, using parallel conduct plus factors or other circumstantial evidence. And so Dan's going to dive a little deeper on what's parallel conduct, what are plus factors, and what plus factors are looked upon favorably by the court. Dan?
Yeah. Hey, thanks, Ellen. Echo Andy's thanks to AAI and to Rust and for Ellen putting this together, and to the other panelists. Before I get started on plus factors, I just wanted to echo one thing Hollis said, which was about how sometimes in cases defendants will characterize a guilty plea or an indictment and try to minimize its impact. As Ellen mentioned at the beginning of the program, there have been a couple indictments recently in the poultry case, or the broiler chicken case, as it's also called. And already the defendants are saying, well, those indictments involve bid rigging. Your case about price fixing is, different, and so, it shouldn't be included there. So anyway, if there's a will, there's a way. But so yeah, on to plus factors and parallel conduct. Just briefly, parallel conduct is what it sounds like. It's when competitors take similar actions under similar market conditions. The things that we usually see in these types of cases are either allegations of lockstep price increases or output restrictions is another big one. Like Andy talked about, there's a lot of different language here about these things. There's tacit collusion, as the economists refer to it, conscious parallelism, as the lawyers call it. But those don't violate Section 1 because there's no agreement. So you need express collusion for things to be illegal. So, and then in terms of plus factors, these are all things that once a court looks at the parallel conduct, then it will look at the plus factors, and then they look to decide whether or not those are going to nudge the allegations of conspiracy over the sometimes referred to as the 50-yard line, sometimes referred to as the goal line. You can pick your own football or sports analogy, but essentially it'll get it into the world of being a plausible conspiracy and get past Twombly. One court described plus factors as conduct that indicated the sort of restricted freedom and sense of obligation that one generally associates with an agreement. So some of the most common can fall under the category of market conditions, which we'll talk about a little bit more this afternoon. But those include things that we usually see about like market concentration. There's not that many players and they cover a large percentage of the market, like Ellen mentioned at the beginning with the beef and the chicken and the pork markets. There's a high barrier to entry, so no one can come in and compete. So it's expensive to start a cardboard factory or things like that. It's a commodity product, so it's only price is really the only thing that people care about. They don't care where they buy it. And that there's inelastic demand, so people are sort of stuck. If prices go up, they have to pay. Other non-market condition plus factors include things like opportunities to conspire. That would be membership in trade associations and attendance at industry gatherings. Also, we're seeing a lot in cases of public statements and kind of responsive behavior. So statements made during analyst calls, calls to arms, looking for industry discipline, you know, the market needs to cut back or this industry is going to lose its shirt, that sort of thing. Actions against economic self-interest. So there you'd be looking at like a small player leading a price increase, which, you know, normally wouldn't happen. And then another one is, you know, past involvement in price fixing. So has there been, you know, guilty pleas or past civil actions regarding the same types of behavior and involving the same types of, or involving the same industry. They need to be considered holistically or together. When courts say, well, like I think the Container Board summary judgment, the district court judge said, well, I looked at each of them and they didn't impress me, so I'm just going to stop the analysis there. And the Seventh Circuit said, no, you've got to look at all of them together. They ended up and affirmed the dismissal, but in any event. There's been I noticed one difference, which I thought was sort of interesting, which is in the Port case, which we'll talk a little bit more about, but that's a case where the court dismissed with leave to replead, but the reason it dismissed was not because of the plus factors. The court noted that the plus factors seemed like they were sufficient, but instead the court determined that there really wasn't a clear showing or pleading of parallel conduct. There were allegations of output restrictions, but they weren't specific to each defendant and weren't matched up in terms of time. So there were allegations of an overall decrease in output and increase in price, but the court said that wasn't enough. But anyway, so the main focus was there. In Saline 1, the court looked at the same thing, determined that there wasn't a plausible allegation of parallel conduct, and the defendant said, well, since you didn't reach that, then the other things don't matter. And the court disagreed, and it said parallel conduct is but one of many varieties of circumstantial evidence that plaintiffs can employ to state a claim. Unfortunately, there it went on, looked at the plus factors, was also unimpressed and dismissed the case. I just want to echo a little bit of what Andy talked a little bit about the motion to dismiss stage and the summary judgment stage, and others have discussed it too. But you know, once you can get past the motion to dismiss with parallel conduct and plus factors, then you know, you got to basically, it seems like more and more, come up with the goods. So what will work at the motion to dismiss stage, once you've undergone extensive discovery and that sort of thing, you know, they're going to be looking for more. And so Clean Products or the Container Board case, you know, got past motion to dismiss, settled with most of the defendants, but then at summary judgment stage, there were 15 lockstep price increases, there were decreases in supply, there were mill closures, you know, a lot of very good evidence, but yet the court found that it wasn't sufficient and granted summary judgment, and the Seventh Circuit affirmed that. Similar in DuPont, which is very interesting because there had been a class case in the District of Maryland which got past summary judgment, but then Valspar filed its own case, you know, an opt-out case, and ended up in the District of Delaware. And when they got up to the Third Circuit, the court looked at the chocolate opinion and drew some, looked at how chocolate dealt with it, what it deemed ambiguous evidence, and dismissed, affirmed summary judgment, even though the same facts that had been pled in the District of Maryland and then in the Fourth Circuit were found to, you know, be sufficient to get past summary judgment. So I think that sort of goes to the issue of who your judge is, but maybe as folks answered that question, the circuit may even be more important than the judge. Let's see, another issue that's come up is maybe a comparison between cases that involve lockstep price increasing increases and ones that involve output restrictions. It seems that there's a little more flexibility in terms of alleging output restrictions in terms of matching up the times and that sort of thing. In container board, the Seventh Circuit noted that plaintiffs had alleged price increases as being lockstep, but then stated that they had overstated that because in some cases, price increases would follow a month or more later. Whereas in the Jones v. Micron case, which is essentially the second coming of the DRAM case, the court noted that the adjustments or declining to increase their own supplies of DRAM are not alleged to have occurred simultaneously, but then noted that that was immaterial because the available case law does not suggest any firm temporal limitations on being parallel. I think one reason that could be is that in terms of lockstep price increases, typically letters are sent out to customers and easily circulate. In terms of output restrictions, I think they're a little bit harder to track, and so that might explain how courts might look at that just a little bit differently. Two other cases I want to draw attention to that I mentioned briefly, but just touch on again, are pork and chicken. So two cases, somewhat similar in their allegations, but like I said, in pork, at least for the first motion, the court dismissed it because they didn't find parallel conduct. Leave to amend was granted. Amended complaints have been filed. The motion to dismiss has been argued, and we're waiting on a ruling. But essentially the allegations were that the defendants had decreased pork production and also had exported a greater percentage of their pork to keep the supply in the U.S. down. But the court essentially determined that plaintiffs had relied on industry-wide data and public statements made by some of the defendants and deemed that insufficient to get past the motion to dismiss.
And if I could interject in there, the pork case illustrates some of the problems that are unique to cases like supply restriction cases as opposed to price increase cases. It may not be possible to be able to get a hold of industry-wide production data, at least on a basis that's could identify each defendant's specific levels of production. And of course, we're talking about pre-discovery. But what's interesting about those cases is that the supply reductions are done to raise prices, and it's rather illogical for certain firms to reduce supply to raise prices that then other firms would get to enjoy the price increase for, but they wouldn't. So, it goes to show you that there are pleading issues, but it certainly is an action against interest to curtail your production in order to raise prices if you don't think there's enough collective movement to do that would then inure to your benefit. That's just my comment on the pork case. But getting that defendant-specific data can be very difficult in those sorts of cases.
Yeah, no, that's very true, and a lot of times, I think they look at whether or not when a producer cuts back supply, whether or not they've done it in such a way that they can't easily recover from it. It's one thing to put out a price increase, and then if it doesn't catch, you can rescind it. But some of the methods of cutting back on output production, like destroying eggs, or it takes a while to sort of come back on them. In terms of plus factors, earlier I mentioned market or industry structure, which people that do these types of cases, recognize them because they are in most complaints, because most of the complaints that are brought in Section 1 cases involve, oligopolistic markets. And so you do have high market concentration. You do have high barriers to entry. The projects are homogenous. So that's a pretty common thing that you see. But it's interesting how some of the courts have looked at that recently. The Saline 1 case said, we know from Twombly and its progeny that industry structure alone cannot get the complaint across the finish line. There's another sports analogy, this one to track. And then it further notes, it cannot be the case that allegations that a market is oligopolistic and a product is homogeneous are sufficient to survive a motion to dismiss. If that were so, an antitrust complaint targeting any industry with those features would survive a motion to dismiss, regardless of whether there were any additional facts suggesting an agreement. Clean Products noted, in treating the market structure of the industry as relevant but far from dispositive, the court is following well-trodden ground. And then perhaps the most dramatic example of this is in the DRAM 2 case, Jones versus Micron, Northern District, California. The court noted, plaintiff's allegations concerning market characteristics are therefore just as likely to be consistent with innocent as unlawful behavior. Allegations concerning the features of the market and its structure are therefore neutral facts. So I think there's been some diminishment of that. In our Doors case that Hollis and I worked together on, there the court did find that the nature of the market qualified as a significant plus factor. And in text messaging 1, although that was from 2010, the court seemed to think it was significant. But I think it may be time for polling question number 5.
Yes, let's pull that one up. What is the likelihood that you would file a complaint alleging collusion based only on parallel pricing and industry-related plus factors, such as concentration, fungibility, trade association meetings? So here we're talking about, you've got a parallel pricing case, you've got a highly concentrated industry, you've got a fungible product there where price is really, there's really no difference between the products, so price would be the only difference. And it's basically describing the oligopolistic industry that we've been talking about today. So would you file that case?
Ellen, could I interject something?
Oh, please do.
So I think this gets to an important distinction that certainly economists have made and that the courts increasingly make as well. The difference between describing an industry that's conducive to coordination, which could just mean parallelism, and evidence that there's something more than parallelism going on, agreement. So it is interesting, as Dan mentioned in the first text messaging decision, Posner cites some of the industry structure issues and he describes them as plus factors. But most of the time they are not described as plus factors. They are described as just sort of the baseline factors that might make us expect to see parallelism, but not enough to allege agreement. One thing I'd like to note though is when you see parallelism in industries that don't have those factors, that should be sort of like super suspect in some sense, because if you have an industry that does not appear to have factors making it conducive to coordination, but you see parallelism, that should be at least a yellow flag. And I'm not sure that always gets as much attention as it might.
So one comment on that, a case that I was involved in related to the oil and gas industry. There was 14 major players when we started the case, and they achieved their parallelism. It was in salary structures through information exchanges. So that's one way of that's suspicious conduct in a case that's in a market that's not highly concentrated. But back to those polling results, if it looks like, if I remember them, that very few people would go ahead and would be likely to file simply, well, 0 would be likely to file simply on parallel pricing and industry plus factors. Everyone else would pause. And some people would keep going on their investigation, which I think is a reflection of our recent experience with getting past Twombly on cases such as that. So where are,
if I can add one more thing, I think
Sure.
another really interesting element that was present in text messaging one, you had, if you recall, one of the plus factors at the motion to dismiss stage that Posner thought was very significant was that both of the key firms had changed their pricing to make it more easy to follow each other. So, you know, an analysis of that would suggest that the market was not as conducive to coordination before that behavior. That behavior was an attempt by the companies to make it easier to follow each other. And that gets to one of the elements that was sort of at the core of the Posner-Turner debate in the 1960s. You need to have some kind of identifiable remedy. And if all you have is parallel conduct, there's nothing you can do to change the fact that companies in an oligopolistic industry are going to observe each other and follow each other. So you start looking, and one way to think about plus factors are things that could be enjoined that would disrupt coordination without loss of efficiency. And I think as we look at some of these cases, you know, a more economic way of looking at plus factors. And in that regard, I'd suggest folks taking a look at the article that Bill Kovacic and Leslie Marks did in the Michigan Law Review back in 2011, where they did an analysis of what they described as super plus factors, but it's a much more of an economist's view of what kinds of behaviors you might see that would suggest efforts behind the scenes, circumstantial evidence of explicit efforts to coordinate, but it also gives you a basis for a remedy, things that you could enjoin. And I think going into that last question, if you can't identify something that could be enjoined and that would disrupt coordination, you have a problem in the pleading of a case.
excellent, good observation. Some may say what you need to do is break up really highly consolidated industries, but that may be for another day.
Yeah, well,
Go ahead, Dan.
yeah, no, that's a great point, Ellen and Andy. I mean, one of the things I found interesting in going back and, you know, rereading some of these opinions is just sort of how courts look at the way that oligopolies work. I think it's in the Seventh Circuit says they've always posed problems for conventional antitrust law. Without something that can be called an agreement, they elude scrutiny under Section 1. And then they go on to note, tacit collusion is easy in these markets, and firms have little incentive to compete on the basis of price, preferring to share the profits rather than to fight with each other. Right. You know, so it's like they're almost basically recognizing, we realize this is bad for, you know, in some respects, you know, for purchasers of the products, but, you know, doesn't go over the line. So what are we going to do about it? But anyway, just briefly, a few other things on some other plus factors. The one we see a lot is, I mentioned earlier, past behavior, government investigations. The DRAM 2 opinion, where the complaint was dismissed, there were allegations of government investigations by other foreign governments. I think the EU and China. The Judge White there seemed to think, you know, what do I care about that? That's not the United States, and they might be looking at different things or care about different things. And just because the government's investigating someone doesn't mean, you know, it just means someone in the government thinks it's interesting. Although he did say that, you know, guilty pleas, you know, from past cases, which the DRAM defendants had pled guilty in the first case, that was something that was, you know, could get closer to nudging the complaint to the point where it would be plausible, but then looked at the other plus factors and determined it wasn't enough. Another thing I noticed a lot is courts seem like they're increasingly saying just because you allege that everyone who's all the defendants belong to a certain industry group, they all go to a certain industry meeting, and they have an opportunity to socialize and play golf and talk to each other. Although that's interesting, a lot of courts seem to be saying that's not quite enough, that really, in order to sort of make something of it, you need to show that everybody was in a room or in the same city at a convention, and then following that, there was some action that took place. Either there was an announcement of a cutback in supply or an announcement of a price increase, but just this concept of, well, there were some increases of prices or some restrictions on output, and then in the background, there were a lot of meetings going on. They want us to start to see allegations that that connect those to each other.
You know, Dan, if I could just interject here.
Yeah.
Going back to the comment about the difference of distinguishing between plus factors suggesting collusion and sort of normal oligopolistic conduct, I think that this gets on a point that Andy made earlier about the effect of importing the Matsushita standard back from summary judgment to the motion to dismiss stage, because oftentimes you don't have that kind of evidence you would need to connect, for instance, the plus factors to and the price increases to the meetings at the pleading stage. And that's evidence that you develop during discovery. And to some extent, that's the purpose of discovery. And so by requiring something more at the motion to dismiss stage, that really has a very large practical effect on the ability to plead a case using the parallel conduct with plus factors model.
And Laura, just in accordance with that, comparing text messaging 1, the motion to dismiss decision, and text messaging 2, the summary judgment decision, one of the big differences is that it was enough in text messaging 1 that there were meetings among the defendants and smaller meetings among defendants, and then something that happened. But when it came time to summary judgment, there was no evidence of what they talked about at the meetings and whether that talking had anything to do with what had happened, and it wasn't enough. So, but I agree with you now, even some of that text messaging 1 allegations just being at industry meetings isn't going to be very persuasive to a lot of courts unless you've got a lot of other suspicious conduct around those meetings.
Yeah.
Completely agree with both those points. We are almost out of time. I'll just touch on one final plus factor that showed up in cases recently, I've seen it recently, although I'm sure it's been around for a while, but sort of information exchange issues, which shows up in both poultry and pork, where they used a company called AgriStats, which is purported to be an anonymous anonymous reports that the AgriStats goes out and collects production information and things like that from its members. It then sends reports around to everyone, and the reports are supposed to be anonymous, although the plaintiffs allege that the producers of the defendants are able to de-anonymize that, and therefore they're able to see what the various details are about each producer's operation, and also able to police the conspiracy. So that's something that's been showing up and is a major part of both those cases. I think, Ellen, what do you think? Polling question? Well,
I think we could do the last polling question. It's about the right time, unless somebody has something they want to ask about or make a comment on before we do that. So polling question number 6, if we can put that up. Agree or disagree? Courts have failed to establish an analytical framework that explains why specific plus factors have more evidentiary value than others, or to otherwise present a hierarchy of plus factors. So we've been talking about this quite a bit. It looks like in the recent hierarchy of plus factors, industry-related ones are definitely becoming low on the totem pole. There's a lot of difference of opinion, I think, on actions against interest, but if you can really get one of those, I think that's really helpful at the motion to dismiss phase. My experience, however, is that what plaintiffs say is an action against interest, defendants will then support with some plausible, defendant-friendly explanation of what was actually going on. So do we have a response yet on this one? Agree or strongly disagree? I think that's probably consistent with most of the comments here. There's some hierarchy, but not enough, and still maybe a significant amount of disagreement over what's really going to matter, what's really going to push the case over the finish line, 50-yard line, goal line, whichever sport you like to play. So I guess we can tie this up now, but any thoughts from the panelists or anyone else about, what can we do to get this area of the law moving in the right direction again? Obviously we can bring good cases and support them and argue them well, but is there anything else that anybody has to suggest about how we can show judges and courts that circumstantial evidence should allow cases to go at least to the discovery stage?
I'll just start by saying it would be great if we could cabin in Matsushita's tend to exclude the possibility. I think that framing has been very damaging, has been overused. It's completely lost its context of being applicable to economically implausible conspiracies. And frankly, I don't know, even if you talk about burden of proof, how you prove by a preponderance of the evidence that something tends to exclude a possibility. I think it's inherently contradictory as a procedural matter. And one thing that could help would be to cabin then in, as a couple of the circuits have. Posner in a couple of opinions has said it shouldn't be read that way. Publication paper in the Second Circuit has said that. I'm not confident that this Supreme Court would be the one to do it, but that would be something that could be helpful.
We said we weren't going to talk about politics on the call today.
I didn't.
I think at a very practical level also, it's helpful for litigants to really be rigorous in drawing the distinction between the stage of the litigation, motions to dismiss versus summary judgment, and being careful in their language when talking about the motion to dismiss stage, allegations versus evidence. Nothing in Twombly or Iqbal has changed the underlying rule that you do not need evidence for a motion to dismiss stage. The allegations that are non-conclusory and properly pled need to be credited, and plaintiffs need to resist the urge to talk about their evidence and how they have evidence that supports this or that, because that is not the standard, and we can't let that become the standard.
It's an excellent point.
Yeah, very good.
Well, with that, it looks like we're about out of time, and unless I see one question that I will look at. Oops, it's just a thank you. That's good. If anybody has any questions or comments, feel free to make them now. But other than that, I would then turn this back over to Laura to say goodbye on behalf of AAI, if that's the way we're doing it.
Thank you, Ellen. One brief administrative note before I do say goodbye, which is that we are in the process of obtaining CLE credit for this event. We've applied for 1.5 hours of Pennsylvania CLE, which most states will recognize. And once we've confirmed the amount of credits, we'll email a certificate of attendance to all of the attendees, which you each can submit to your own state CLE board. And on that exciting note, I want to say thank you so much. This has been a terrific discussion. Thank you to Rust for hosting. Thank you to Ellen for her excellent leadership of this panel. Thank you to our panelists for the terrific discussion. And thank you to all of you who attended. This has been a real pleasure.
Thanks, Laura, and thanks to the panel members. Good to talk to you all, and hope to see you in court in a good case someday.
Thank you, Ellen.
Good.